I've got another really interesting report here from the local government social care ombudsman, this time Manchester City Council, and this time £5,500 compensation, and it all revolved around failures to someone at risk of and experiencing pretty significant domestic abuse. It also covered things like reasonable adjustments for someone with autism, and it also covered out of area placements for someone who wanted to remain in the city. This is often a bone of contention with the local authorities, because if you say you're at risk of domestic abuse, they'll immediately say you need to be housed somewhere else without actually assessing you and your family members at all. So if I go through a bit of a timeline of events, it just gives us a bit of context, and the findings and the recommendations from the LGO were brilliant. Keep saying LGO, it's the LGSCO now, but I'm just, been around for a long time. So Miss X, she's called here, obviously she's anonymised. She approached the council initially in December 2022. She explained she was experiencing significant domestic abuse, and also she explained that she had autism, which in part meant that she struggled to take in information, particularly when it's complex. Manchester City Council sent some policies over, the privacy notice and so on, all of which use legal jargon and makes it difficult for any layperson to understand really. She initially said she was reluctant to go into interim accommodation because she didn't know where it was going to be, and she had a joint universal credit claim with her ex-partner, and basically was worried, understandably, that she wasn't going to have any income at all, so didn't know how she was going to get by if she was in temporary accommodation. So Manchester City Council failed in a number of ways throughout this process. It actually lasted for nearly a couple of years really, and an interesting point on this case is, as far as I can tell, Miss X went straight to the local government social care ombudsman rather than going through the council's complaints process, because there's no mention of complaints in there, and the ombudsman does have the ability to exercise its discretion and investigate cases where there is a live issue. In this case obviously was due, because at the time of writing this decision she was still in that situation as far as I could tell, even though the council had a duty to provide suitable accommodation months if not years before. Now the council carried out an assessment, as they should do if the prevention or relief duty is engaged with, and they should have identified the fact that this issue of the joint universal credit claim was something that they could advise her on and help her out in order to kind of help her flee the property. And the issue of whether the prevention or relief duty kicked in was another bone of contention in this case, because legally speaking, if you are at risk of domestic abuse now, you are legally homeless now, you do not have to flee. The prevention duty should not ever kick in cases of domestic abuse, unless you've got situations where, for example, the perpetrator is about to be released from prison, so you're not actually at risk right now, but it's likely the risk will return as soon as the perpetrator is out of prison. But other than that, if you're talking about domestic abuse, you should be talking about relief duty rather than prevention duty. And just, excuse my jargon, the prevention duty is owed to people who are likely to become homeless in the next 56 days. The relief duty is owed to people who are already homeless. And so over the coming months, she reapproached the council numerous times. She told them about what was going on, and basically the council did things like say, oh, we can help when you actually are homeless, but we can't tell you what that's going to look like until the day. Then we can put you forward to temporary accommodation, which is not the same thing as saying we'll offer you temporary accommodation at that point. And just, sorry, another bit of jargon I'm talking about, I realise. Technically speaking, you've got two types of accommodation that you're going to get offered by the council in the homeless application process. So one is interim accommodation, which is also known as emergency accommodation. You've then got temporary accommodation, which is the accommodation which is given to you once the main duty is accepted. And in even more jargon, the main duty is owed to people who are homeless, eligible, in priority needs, not intentionally homeless, and local connections taken care of in one way or another. So anyone who is at risk of domestic abuse will immediately satisfy the fact that they're homeless, they are in priority needs, they're not going to be intentionally homeless, and local connection doesn't really matter. So provided you're eligible for assistance, as in you have recourse to public funds, if you are experiencing domestic abuse and approach a council, you can basically guarantee that they're going to owe you the main housing duty unless they house you before it gets to that stage in suitable accommodation. So Miss X also explained to them the difficulty she was having with care of her child, because she didn't want her child to be put in some random location in interim accommodation. She didn't know about schools, and the council did nothing to reassure her on those issues, or kind of work with her to work out how that might work out in practice. And in the August of 2023, the council then made what's called a final accommodation offer, which I think was in another town or another city. And she'd already kind of said that's going to be difficult. She'd already been told by that stage, in effect, that she could refuse an offer of accommodation and they would give her a different offer. And so there was obviously miscommunication within the team between who was doing what. And so in effect, she had to then kind of dig her heels and say, well, hang on a minute, I have refused it, but you told me that I could refuse it and I'd get another offer. And again, Manchester City Council had that in their records, so she could prove that that was the case. She then asked for interim accommodation again a couple more times before anything really kind of moved forward. And the LGSCO made a number of findings which are interesting in this case. So firstly, there was no evidence from Manchester City Council that at any stage they had taken her disability into account and kind of basically worked out what reasonable adjustments they might need to make. This report does a great job in explaining what these kind of duties mean in a bit more context, so do check it out. I'll put the link in the description of the video. So it's worth reading in full because it lays out what the law is, lays out what happened, and then lays out what their recommendations are. Secondly, the council failed to explain to Miss X what she needed to know in an accessible format, so she was essentially trying to make sense of this ridiculous process without kind of actually having it explained properly to her. And as I say, she told them that she struggled taking in complex information. Thirdly, there was this confusing information about whether the final accommodation offer was a final offer, whether she could refuse it and whether they'd have further duties to her. And there was this big failure, in my opinion. This is kind of one of the most common failures you're going to see in domestic abuse cases, where the council incorrectly think that the prevention duty applies rather than the relief duty. As I say, the relief duty is going to be the one that applies in almost all cases involving domestic abuse. The LGO then said that the main housing duty should therefore have been accepted in February 2023 because the relief duty should have started in December, and the relief duty should only last for 56 days in most cases. And this was a straightforward case legally. I appreciate there were some complicated things that the individual had to deal with, but legally speaking this was about straightforward as they come. Instead, they accepted the main housing duty in December 2023, so that's a delay of 10 months or whatever it would be. And interestingly, the LGO also said that the Manchester City Council had not actually made suitable interim accommodation available, and instead had said, we'll put you forward for temporary accommodation with the temporary accommodation team, which is not the same thing as an actual offer of temporary accommodation. So that might seem pedantic, but that's actually kind of an interesting point. And there was again no offer of temporary accommodation provided once the main duty was accepted in December 2023. And there was no attempt to support her with the universal credit claim, because that again was kind of one of the issues that she had, that she didn't quite know what to do with at the start of the process. So those were the findings. As I say, this is a systemic issue. This was not just one housing officer getting it wrong a little bit. This was multiple housing officers getting it wrong over the course of many months. Potentially there were questions about the policies and the procedures that were being in place anyway. There were definitely questions about the training that the team had, because clearly they obviously either had never been told about the reasonable adjustment duty or had systematically refused to engage with it. Again, the report is really rich in terms of information. One of the points it makes further up is that the duty to make reasonable adjustments and to take disabilities into account is an anticipatory duty, which means that councils have to anticipate what kinds of issues will people be approaching our service with. And autism and other disabilities are very common within homeless services because it's kind of one of the risk factors of being homeless in the first place. And therefore council can't say, oh, well, we never, we don't have any wheelchair accessible accommodation because we just hadn't thought about it in advance. Obviously, people who need a wheelchair or who have other disabilities like autism will be approaching the housing option service, and so the council need to have already got in place things that are going to enable them to make those reasonable adjustments as they come up. That is a big issue across the country, and one which you can actually get quite a long way with in terms of campaigning for better practices in your local area. There was a couple of other findings as well which were interesting. So the council never actually assessed the suitability of an out of area placement. So although they kind of said, if we provide you temporary accommodation, it could be in another area, they never actually sat down and said, okay, we need to actually look at how that is going to affect you and your child, how that's going to take into account your wider support needs, and essentially how we are saying that it's going to be suitable. And it's worth looking at a few paragraphs in a bit more detail. So when we get to just before the actual agreed action, there's paragraph 50, which I'm going to read in full because it does quite a good summary of kind of putting all this together. So as a result of all these previous failings, Miss X has not been properly supported. She has not understood her options, feels misled and pressured to move to an unfamiliar location without any details about where or what this might be. The LGO says, I cannot say that Miss X would have accepted an offer of interim accommodation had the council made one. However, it denied her the choice. This is a significant injustice. So although she was understandably kind of worried about how it's all going to work out, how her finances are going to be managed, and so the LGO is saying, well, even if they had made a suitable offer of interim accommodation, they can't say for sure she would have accepted it. The fact that she didn't even have that choice was a significant injustice. Goes on to say the council should have accepted the main duty in February 2023. At that point, the council had a statutory duty to provide suitable accommodation. It has not done so. As a result, Miss X remains living in unsuitable accommodation where she experiences domestic abuse. This is a significant injustice to Miss X. So then looking at the agreed action. So I love these reports. They're just kind of very logical. So the agreed action, I won't read it all out, but I'll read out a few bullet points. The second bullet point, make Miss X an immediate offer of specific and available temporary accommodation, having considered what would be suitable for Miss X and her child. So this decision is dated May 2024, and so by this stage, I can assume that the council had still not made an offer of accommodation at this point. Fourthly, pay Miss X £1,000 in recognition of her avoidable distress, uncertainty and missed opportunity to access interim accommodation. And then fifthly, pay Miss X £300 a month for each month she's remained in unsuitable accommodation, since the council should have accepted the main housing duty, for a total of £4,500. Now, if you watch my videos, you'll kind of notice that I tend to be a little bit of a contrarian, and so I would also want to see the LGO potentially consider recommending a payment for the risk of harm and the actual harm that she suffered during this period, because she was subject to at least 2 physical assaults during this period. There was obviously kind of, indications of various other types of abuse as well. And that, obviously the council didn't cause those abuse, it was the perpetrator, but their failure to discharge their duties lawfully earlier on left her at risk of that harm. And as I say, she actually came to harm. So if you look at the local government social care ombudsman's guidance and remedies, you can just Google it. I might even put the link to that in the description just to be helpful. But it sets out the framework. They calculate how much money to give, and there is a separate strand for harm and risk of harm. So I think I haven't read it for a while, but I'm pretty sure if it says you actually come to harm, you should get about up to £1,000. And there's an additional strand as well for outrage, and I would have argued that this is outrageous because you've got well-established law being systematically breached by a council. It's not just one-off failures. It is, happens over the course of many months in slow motion. It involves discrimination. I would argue. I'm not quite sure if technically it is or not, but disability discrimination. And I would say that's outrageous. I would be outraged by this. If this was my council doing this, I'd be like, I'd be asking questions in the local housing committee. And basically saying, how on earth has this happened? This is clearly just not a one-off. This is a failure of leadership, a failure of the system itself. But as I say, I'm just a contrarian, so I don't know whether those payments would have been recommended had they been raised, or if they needed to be raised. I'm not quite sure. But that's just a bit of additional commentary on that. And then another interesting point here is that the council was also basically told to take certain steps. Now, the LGSO can't make councils do things, but they can recommend it, and most councils will comply with the recommendations, because it's obviously the right thing to do. So, and I think I'll read them all out because they're all interesting. So firstly, provide training and or guidance to relevant staff about autism and reasonable adjustments in line with the Greater Manchester all-age autism strategy. Now, it's interesting they've got this strategy. This is a good example of street-level bureaucracy. I'm using that term from a book by Michael Lipsky. Really great book if you kind of like the theory of all this stuff. And basically what he says is no matter how good your leadership is, no matter how good your mayor is, and bear in mind this is Manchester, so it's Andy Burnham, who I think is pretty decent, no matter how good your top level leadership is, what really matters is what happens on the front line. And what you often get is frontline officers almost directly sabotaging the attempts of the leadership to follow the law and kind of work well. Now, there's obviously more to it than that, but the fact that they've got this strategy and the fact that it appears the whole housing team have never had training on that strategy and are in a sense not even complying with their own policies, let alone the law, would be a kind of a significant point that the LGO is picking them up on that. Also recommends that relevant staff to record their consideration of cases of domestic abuse in terms of whether the person's actually homeless already, which is, again, should happen anyway. Ensure that information provided to homeless applicants includes sufficient information and detail about the options discussed in any assessment and reiterates any advice given verbally. Remind relevant staff of the duty to provide interim accommodation to homeless applicants who might be homeless eligible and in priority need, and that to be an offer of accommodation, the accommodation must exist and be available to the applicant. Consider making any offers in writing. So that's a really interesting point which probably crops up a lot in a lot of different cases. Remind relevant staff that in cases where a homeless applicant has not taken up interim accommodation or has refused an offer, the council must still provide temporary accommodation if it accepts the main housing duty. Now, that's a really important principle anyway. I would argue that in this case that the council should have been very, very flexible with Miss X in this situation, because clearly she was not just refusing it for the sake of it, she was clearly refusing it for concrete, reasonable factors, things like the affordability, how is she going to afford things if she's not able to receive universal credit. Those were things the council should have basically dealt with themselves. And so I would say that even if she had turned interim accommodation down for those reasons, rather than saying, oh, we're going to wash our hands of you, the council should have actually worked with her flexibly to kind of see that through. And then finally, and this is really interesting, and I think if I've ever loved the LGSCO, it's now, because they basically recommend that using this case as an example, discuss with relevant staff the challenges and barriers victims of domestic abuse can face in leaving abusive situations, and identify the steps the council can take to support victims and create the best opportunity possible for them to leave. That's an outstanding recommendation, because what if the council follow through with this and actually do it, what you're going to have to do is you're going to have to get the staff team in a room together and say, look, this has happened, and let's go through all the different things that, the ways in which you failed as a team. But also, if they're going to follow this recommendation to the letter, they basically have to ask the question, what is it actually like for a victim of domestic abuse to approach the council? What do they actually need at that point in order for us to do our job to not only discharge the law, but also to create the best opportunity possible for them to leave? That's I love that. That's really good practice, and I think that psychologically it's going to be very difficult for staff, if you were to do that exercise with them, to then go and make the similar mistakes in future, because the good officers tend to get browbeaten by management into breaking the law. I can't say whether that's the case in Manchester because I don't know them personally, but in many councils it would be. And by having that kind of explicit expectation that staff follow the law based on previous failings, it makes it very difficult psychologically for a housing officer to then go break the law, because they can't just kind of do the sort of mental gymnastics and kind of ethical gymnastics to justify it to themselves. They're having to face the fact that their team that they are part of made these various failures, and that it's not acceptable going forward to do so. So I would hope, if Manchester management followed these recommendations, that you're going to see a marked improvement for the services they provide to survivors of domestic abuse going forward. So yep, great decision. As I say, really refreshing to see this sort of stuff from the LGSCO. If you want to see more of this, just go on their website, lgo.org.uk, and just browse their decisions, and you'll see, cases where the complaint is upheld, cases where it's not, the reasoning for it. It's just a fantastic way to learn. There are things within that website which I have not seen explained anywhere else. So particularly things like the interaction between the Equality Act and disabilities and housing law. Yeah, this is by far the best resource I know of that kind of explains that in detail. And it's trustworthy, it's the LGSCO, they know what they're talking about, so it's not just some random guy on YouTube saying it. It's really well thought out and explained stuff, so yeah, as I say, well worth checking out. Hopefully this was helpful. If you've got any questions about this or anything else, put it in the comments anonymously. Do not ask questions about your own situation, just make the question about a hypothetical person. So what if someone was at risk of domestic abuse and the council were told under prevention duty kicks in? You'll get the same answer, but crucially, you don't have to put your personal data onto the internet to get the answer. And it also helps you distill out what the legal questions are you have and what things might fall outside of, what we can answer. So yeah, check out the weekly live stream Thursday 7:30. You don't have to watch it live, you can watch the recordings. But any questions that get put in the comments, I'll either respond to straight away or I'll take to the next weekly live stream to give us a bit more space to explore it.